Hi everybody. I'm going to talk a little bit about this new class that we have together called Litigation. In litigation for paralegals, we're going to discover a number of important concepts. So this is just an attempt to give you a little bit of an introduction, and then as we go along through the course, I'll try to give you some tips on important things that you're going to see from week to week in our course in litigation. So some of the important things that we want to consider are some, of course, of the definitions. For example, litigation is basically another term for a trial. Now, litigation has a lot more parts to it than a trial. Let us say that trial is part of litigation. Leading up to the trial, there are a lot of things for paralegals to do, and that is why we have this course in litigation. In the early stages of a case, there is interviewing and a lot of organization involved in terms of pulling the information together that's going to be needed to be used in the trial. So the big job that the paralegal has is trying to develop an outline and organize all the material so it will be at the lawyer's fingertips when he's in the courtroom. I can tell you in my own experience that some of the best success that I had in cases in trial involved the use of a paralegal, because the paralegal had the file so well organized, everything just seemed to fall right into place. So as I would come to a witness, here there would be a folder already laid out for that witness, everything to look out for, the important questions to ask, and so forth. So in reference to this class, then we want to, first of all, explain that it's about litigation. My name is Rob Dawalt, and I will try to help you get started in this. And so the big thing to expect in terms of your role in litigation would be a lot of work that's done prior to the trial and not so much work that's done in the courtroom. There are instances where I've known some trial lawyers bring a paralegal and have them sit on the front row, especially in large complex cases where they can actually hand exhibits and things to the lawyer across the rail. Sometimes judges will allow the paralegal to sit inside the rail, but usually they're going to make the paralegal sit on the front row and then just pass the material across the rail. In my experience, that varies from court to court. The process is involved with a complaint. That's one of the early things that you're going to work on, is to develop a complaint. But it is not as simple as just coming in on the first day and working up a complaint. More and more they're becoming more stiff in respect to that, you actually have to prove the things you put in a complaint. If you cannot prove the things that you put in a complaint, then your case may be termed frivolous. And no lawyer wants that to ever happen. So anything that you put in the case, you have to have the evidence at your fingertips in order to prove it. So basically, well then, the first thing you need to do is organize your evidence, find out who said what, and develop the complaint based upon the information that you're able to pull together. And so, these are important considerations today. So you'll have a lot of things that come up before the complaint. This involves interviews and photos, doctor bills, and all this needs to be organized. Then also the doctor is going to make a statement about what happened. So that's a pretty important part of what we're talking about. of things to also consider, and you should have already had this class, called civil procedure. In fact, it's more or less the prerequisite for litigation is to have a course in civil procedure. So it's important to understand. One of the early things I think that you cover in civil procedure is kind of the difference between civil law and criminal law. It is interesting that the civil procedure can affect criminal cases. Criminal case is usually brought by the state against an individual or even a corporation, whereas a civil case is some kind of a dispute between private parties. So not the government in terms of bringing a criminal case, but instead a lawsuit. Could be a divorce, could be a bankruptcy, could be a car wreck, someone slips and falls in the grocery store, a lot of different things that would qualify. There's also contract cases where people owe people money, or people claim that people owe them money. And so there's a lot of different ways that disputes can involve civil procedure and civil law. Okay, so it's important to know that there is a difference between criminal law and criminal procedure and civil law and civil procedure. But one thing I do know is that civil procedure is kind of overarching, and so if there is no statement as regards criminal procedure, then the civil procedure could apply in that situation. Well, who are the parties? I know that a lot of people get confused on this one. Usually there are going to be at least two parties, and that is a plaintiff and a defendant. Now, people get confused a lot of time on which is which. The plaintiff, brings the case. He's the first person to file a complaint, okay? And then the defendant answers, has to file a written answer, okay, in most cases. Now, there are some exceptions. For example, in juvenile delinquency, they've done away with defendant, the use of the word defendant. They may use the word delinquent or respondent or something like that. Same way in divorces, you have petitioner and respondent. You don't have plaintiff and defendant. Well, that seems kind of easy. Plaintiff brings the case, defendant brings the answer. But the problem that you're going to get involved in, and this is something that when you look at the curriculum of record, they talk about this. Well, what if the defendant files a counterclaim? Now, try to spell it right. Well, in that case, then the defendant becomes the plaintiff in the counterclaim, and the plaintiff becomes the defendant. So it can get a little bit confusing. Defendant. So in other words, the best way to refer to it is counterclaim plaintiff, and then plaintiff, counterclaim defendant, okay? So, that does come up. It comes up a lot. For instance, there is a car wreck. Someone says the light's green for the plaintiff. Someone else says the light is red for the plaintiff and it's green for the defendant. So the defendant claims that the plaintiff ran the red light, and the plaintiff claims that the defendant ran the red light. Perfect example. And I've been in cases like that. It's very confusing. So, that's just one example. What about a crossclaim? Well, in a crossclaim, and basically what you can have is you can have two plaintiffs, and let's say one defendant, okay? Well, let's give an example, okay? We got a car that's got two people in it, all right? So we'll try to draw a picture of a car here, okay? So this car is like going this way. This is kind of the way we do it. And then there's two people inside, okay? All right. And then let's say that there's a light here, and the defendant is going this way, and that's just one person in that car, okay? And of course, you know what's going to happen. They hit each other in this intersection, okay? And of course, then we have this dispute. You know, like bam, here are these two cars just hit each other. It's all bent up. We got to make it look like, oh my, there's a big bang, where they hit each other. Okay. Well, let's say in the cross-claim, plaintiff 1 is the driver, plaintiff 2 is the passenger. Okay. Well, the defendant, which we usually make a little triangle for defendant, kind of like a D, but it's also more like an equilateral triangle, okay? Well, if the defendant, he doesn't want to sue this guy because this guy didn't have anything to do with it, so he'll just come around and sue this guy, okay? So he would be the cross-claim or cross-complaint plaintiff. Now the mark we make for plaintiff is looks kind of like that, okay? So that's a mark for a plaintiff. But the plaintiff is also the cross-claim defendant, okay? So let's try to clean this up a little bit and mark it, okay? So we've got, in this particular case, we've got P1, and then he's also cross-complaint defendant. We've got P2, okay? Then we've got the defendant and the cross-complaint plaintiff. Okay, so that's kind of how you would do that if you're just trying to do some quick notes inside your office as to who you're talking about, so that you can keep track of, all these different players. Well, there's at least one other thing I need to cover on this, and that's the concept we call impleter. Okay, impleter. Okay, and I actually had this kind of a case one time. Now, okay, what happens is, school bus is sitting by the side of the road, okay? We got lights, 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 lights. But there's no stop thing here. He didn't put a stop sign out, okay? And they're yellow lights, okay? Yellow, not red, okay? And so a lady in a car comes along like this, and a kid gets off the bus. This is a little girl. We've got her in a dress here. She's got her little feet going this way, and there's her arms. So this lady doesn't really see the light because she's already up in this area when the little girl disembarked the bus. And so the lady goes this way, the little girl goes this way, boom. The little girl gets hurt pretty bad. She messes her leg up. She's got lifetime injuries to her leg, okay? Well, okay, so what do you suppose I do? Well, I represent the plaintiff, okay? Actually, the mother of this little girl, okay? And we sue this lady who is the defendant, okay? And so what does she do then? Well, she brings a complaint against the school corporation. Okay, and so that's the impleter defendant, okay? So what did I do then? Well, I turned around and asked for leave to amend my complaint to add the school as a defendant. And this was well taken because they did not have the stop sign out where it belongs. It was just up against the bus, okay? So stop sign is supposed to be out like this, okay? So that's the kind of thing that you can get into when you have these kind of complex type situations where I did not know those facts until we took the interview of the defendant driver. Said, well, I was already past the lights, so I didn't see any lights, and they didn't have the stop sign out. Well, finally the driver admitted, yeah, I guess I forgot to put the stop sign out. So it ended up that both defendants paid, but as you can see, the one defendant paid less because they were able to share the cost of the case with another defendant. So they were able to shift some of the blame in the case to the school corporation and the driver of the school bus. So these are just some of the things that you can get into when you work on these kind of cases. Now, like I said, sometimes you file a complaint, you think you know all the information, things change, just like I demonstrated for you right there. Also then, as we go along, we're going to get involved in issues like discovery. And so I mentioned a couple things. We took what we call a deposition of the driver, the lady driver, and then we also took a deposition of the bus driver, okay, and the little girl had to give a deposition, of course, like 12 years old, and then the doctor has to give a deposition. So there's at least 4 depositions right there in these situations that I explained to you. So this is the kind of thing that you get into. Well, a lot of times in discovery, before you actually do the depositions, you go through other steps. And let me describe what some of these other steps are. In addition to the depositions, you'll probably start off with what we call interrogatories, which is questions that you put to the opposite party. And then also there are other aspects of this, including a request for production. A lot of times the defense will want this because they want to see the doctor bills. They want to see the doctor's report. So they'll ask for documents called request for production. Another way of getting that is what we call subpoena ducis tecum, and that's Latin. Basically what it's saying is that you would serve, along with the request for production, a subpoena to bring the documents, and that's what that means, subpoena, bring the documents. And so those are some important aspects, and that helps the lawyers get ready for the later depositions that you know they're going to want to do. Now, who do you suppose prepares these interrogatories? Who do you suppose prepares the subpoena ducis tecum? Of course, it's going to be the paralegal or a secretary under the supervision of a paralegal in a large firm. Now, in addition to requests for production and interrogatories, then you can also file a request for what we call an IME. What's an IME? Well, an IME is an independent medical examination. Independent medical examination. Now, most plaintiff's lawyers will tell you that an IME is really misnamed because they claim that a lot of these doctors that defense lawyers use, they use them over and over, and so they have some rather unpleasant words to share about an IME. But that is also part of it. You are allowed to get a separate medical evaluation. Now, last thing is the request for admissions. Let me give you a good example of this. It doesn't come up too often in car wreck cases, but it can. What if a plaintiff wanted to file a request for admissions against a defendant, maybe the lady that hit that little girl, got really upset and jumped out of her car and told the police officer, "It's all my fault." Okay? Well, you might want to file a request for admissions to get them to admit, yes, I said that. That would help because it would confirm what the police officer wrote in his report. So it starts to boil the whole thing down so that you don't have so many things that you have to deal with. Another thing I want to touch on is in addition to classical litigation, we have what we call ADR, which is alternative dispute resolution. Okay, alternative dispute resolution. And one of the most favored in recent times is what we call mediation. And mediation involves experts in the law, like a lawyer that can take additional training on how to be a mediator, or in some domestic relations cases, there can be mediators that are also psychologists, counseling psychologists, people like that will work with people who have issues with their marriage and things like that. So it is possible for mediators to be involved in a lot of cases. A lot of courts now are requiring some form of mediation, so that's something to keep in mind. And also, an older type is what we call arbitration. And arbitration, that can have like a 3-judge panel. You'll see arbitration a lot of times in labor disputes between the union, large corporations, things like that. Pretty rare in like civil disputes. I did see in a contract case one time that we were required to go to arbitration. But what we agreed on was having a retired judge act as the arbitrator, and truthfully, it came down to pretty much the same thing as a normal trial. The big difference is, though, that some of the rules of civil procedure are relaxed in arbitration, so it's not quite the same as a real trial, but the preparation is going to be pretty much the same. Well, I hope this has helped you a little bit to understand the first few chapters of our book in litigation. We will be doing a few more of these from time to time. As far as getting oriented to this class, very important that you go to the course online, look at the syllabus, print off a copy, read it all. If you have questions or problems, you can always contact me. And I'm going to put my email address. I'm going to put a different one up here in case you're having trouble getting a hold of me at the original. It's robdawalt@me.com. Okay? So get a hold of me. I'm also available by phone, 765-506-7322. Okay? So if you need me, you can call me or you can email me. But mainly look through your syllabus and decide just exactly. If you have any questions, feel free to get a hold of me. And then the other thing that we're going to be doing here, the backbone of this case has 2 parts in litigation, and that is you're going to need to do a trial notebook, okay, trial notebook. And basically it's examples of everything, and this is to your benefit because a trial notebook is a good way to show that you know what you're doing. So you take it in for an interview for a job, it might help you get a job because you can say, I know how to prepare a complaint. I know how to prepare interrogatories. So that's an important part of it. The other thing is, in this course, important thing is the discussions. So you should always be prompt and do your discussions in your online class. Since this is an online class, I am going to want you to use technology, electronic methods to preserve your trial notebook rather than mail it to me as we've done in the past where it's a bulky big mailing envelope and all that. We're trying to work on using the internet as a way of sharing your online trial notebook. So we're looking at like an e-portfolio approach to this. I've shared some of that, some of the discussions. So what we want you to do is play with that in the early going. I'll work with you on it. First time for all of us. It's new to me too, so nobody get upset or excited, but we are going to try to figure out a way to better handle these large documents. Instead of having to mail them, which costs you money, we're going to use no-cost internet technology that you can submit these large documents to me and then go over them. Then I'll send you a note, tell you, the changes that you need to make and then you can send a final copy to me. So that's what we're going to try out this summer. So give it a go. Let me know if you have any problems. I'm always available. Thanks a lot. This is the first of many of these video type lectures that I'm going to do for this class.